Professor, I'm Yun Kun. Thank you for giving us this chance to present our study. We are Team A. Today we are recording our part of our video in the cafeteria in CBU, so we apologize for the occasional noise. In our case, our client refused to follow our suggestion that pertain to intellectual property rights and how to defend their rights simply because they do not understand its importance. To make them understand better, our report used three main sections to explain and emphasize the importance of IPRs. Firstly, we explain briefly the term intellectual property rights in an easily understanding way along with an illustration. Secondly, we discuss the importance of IPRs in respect of the needs for IPRs as an individual, group/organization, and the whole society. Thirdly, we propose 5 practical tips for our clients to deal with IPRs during their business conduct. The primary points derived from the 3 main sections are listed in our report and will be mentioned again in the incoming presentation by my teammates. So without further ado, I'd love to introduce Harjot to start with what are intellectual property rights.
Thanks, Junkun. Now I'm going to explain what is IPR and why it is important. Intellectual property rights include invention, literacy, work, design, symbols, images, and names used in commerce. Copyright, patent, and trademark are the types of IPR. It allows the owner to gain reputational or financial benefits. Furthermore, user of IPR also play important role because without mass utilization, many inventions did not flourish. IPR is important because it encourages innovation and also helps in economic growth. For the safeguard of rights of creator, we need IPR. That's why it's important. So now my teammate Prabhjot Singh will explain further.
Thank you very much to Harjot Singh. My name is Prabhjot Singh. So I am going to explain case 1, which is estrogenica Canada vs. Apotex. In this case involves a challenge to the validity of the estrogenica patent number 653 for want of utility. AstraZeneca is a global pharmaceutical company selling a gastric drug named Nexium. On the other side, Apotex is Canadian pharmaceutical company. The main issue in this appeal is whether AstraZeneca's patent is invalid for want of utility on the basis of the promise of the patent doctrine. The federal court ruled in favor of Apotex. In accessing utility, the federal court relied on the common law promise of the patent doctrine, the promise doctrine. Moreover, the court found that the promise doctrine was burdensome to a fundamental bargain of patent law, the grant of a temporary monopoly to an inventor in exchange for the disclosure of their invention to the public's benefit. Due to the onerous standards of the test, patentees may be discouraged from disclosing fully where fulsome disclosure is to the benefit of the public, as the promise doctrine was contrary to the scheme and purpose of the Patent Act. The SEC ruled that it was not good law and upheld AstraZeneca's patent rights. In discussion for patent holders in the pharmaceutical and technology industries, greater protection and peace of mind is offered by the understanding that fulsome disclosure in the specification of their vast patent portfolios will not jeopardize their patent rights. Now my team member explain further details on this case. Thank you so much.
Myself Kalwinder Kaur, and I'm thankful for Prabhjot Singh for giving me a warm welcome. I'm here to discuss about the case 2 and case 3 parts. Case 2 is about the Dow Chemicals and Nova Chemicals. The mentioned case has been governed between the Dow and Nova Chemicals competitors. So it is identified that due to the misuse of royalty and trade secrets of the Dow Chemicals, Nova Chemicals need to pay the monetary compensations to the enterprise. On the decision of federal government of the Canada, Nova Chemicals need to pay around $506 million as a compensation to the Dow Chemical for the misuse of the trade secrets and being not following the royal customs. It is derived that the instrumental role of playing in protecting the overall invention of individual along with the considering legal rights for utilizing the invention are the core concern for patent which is maintained during the IPR process. So the case study was mainly it was mainly between the Access Copyright versus the New York University. The as per this, in this, the New York University was accessing the digital work from the online sources within considering the traffic paying procedure. Tariffs are one of the tax which we need to pay the government if we are using any the patent property. So according to case, it is observed that New York University is using patent digital work for their own business procedures without paying the tariffs to the government. In regard of this, Copyright Board of Canada filed a case against the New York University. In the entire copyright content is available in the digital media for facilitating the educational procedures. On the other hand, university also denied for paying the compensation which additionally caused IPR, intellectual property issues for Canadian government. So this was all about the case 3 and 2, and thank you. And next Karanvir is going to explain about the case 4 and case 5. Thank you so much for giving your time.
Thank you, Kalwinder, for giving me the opportunity. My name is Karanvir Singh. I'm going to present two cases. Case 1 is Google versus Accustech. In this case, against Accustech for violating the indexing standards of the Canadian government. The concerning suggestion to the enterprise directly violate the high defense degree of the Canadian regulation, which additionally caused the IPR loss. Also, Accustech has lost its IP due to the unauthorized accessibility of data link and the de-indexing mechanism. Further discussion has been made on the critical issue regarding IPR protection, in which the use of copyright and patented product of Accustech by Datalink. The mentioned incident directly violates the IPR of business enterprises. Therefore, to protest the incident and reduce the business loss due to the IPR loss. This issue also damaged the overall brand image of business enterprise. In case 2, Diageo Canada versus Heaven Hill Distilleries. This case deals with the guidance avoidance attribute of Heaven Hill Distilleries regarding the unauthorized use of alcohol bottles invented by the Captain Morgan. It is observed that the Captain Morgan uses a label trademark in each bottle to protect the core IP of the enterprise. The Heaven Hill Distilleries have used the same trademark for generating profit within Canada without giving royalties to the patent enterprise. In discussion, according to the Selva Kumar, the trademark overlapping phenomena during business management procedures can be regarded as the key IPR issue of the brand, which can directly impact the entire business operation of the enterprise. Now further discussion on recommendation will going to explain by my teammate Vishal. Thank you.
Thank you, Karanvir, to give me this opportunity. So my name is Vishal and I'm going to further discussion on recommendations. So navigating IP related issue in the international trade environment can be tricky, complex and burdensome, especially for small and medium-sized entities that lack the legal spending resource of more giant corporations. So I highly recommend some parameters to my clients so that they can protect their intellectual rights. First, I will suggest my client to register their copyrights and trademark in countries where their products are made and sold, because it prevents a counter notice or even infringement, and clever infringers will know that your options are limited if they don't register their copyrights and trademarks. Secondly, I will also recommend my clients to keep quiet about their trade secret in emerging markets. Moreover, I will also warn my clients about the question about the subcontract, because if my clients allow their manufacturers to subcontract the production of their products, it is wise to enter into a separate agreement with the subcontractor to protect their intellectual property. Last but not least, I also recommend my clients to keep an eye open and educate consumer to serve as their eye and ear if they are short of eyes. So this is the end of our presentations. We sincerely appreciate your attention today and would like to thank you for your time and your interest. Thank you.